Fire Away tackles burning questions and hot topics in Canadian employment law, human resources, and dispute resolution. Hosted by Rudner Law, Fire Away is your go-to source for legal insight on the world of work. So whether you are an employee or an employer, a lawyer or an HR pro, let's ignite the conversation and get into today's episode. Here's your host, employment lawyer, mediator, and founder of Rudner Law, Stuart Rudner.
So with that, let's go to the look ahead, and we're going to be coming back to legislation with Brittany, which will include new job posting requirements, and you can tell us what else to expect in 2026.
Absolutely. Thanks, Stuart. Okay, so a lot of people have been talking about the new job posting requirements. As Stuart mentioned, these are coming into effect January 1st, 2026. Now, these only apply to employers with 25 or more employees on the day a posting is posted. So again, if you're a small organization, you don't need to worry about this. This also only applies to publicly advertised job posting. So an external job posting that an employer or a person acting on behalf of an employer advertises to the general public in any manner. Okay, so those are the stipulations before we get into the actual requirements. So what are postings going to have to include after January 1st? They're going to have to include an expected compensation range. So an employer has to include information about the expected compensation that the person is going to receive, and it has to be in a range not exceeding 50,000, right? So it can't be $0 to $300,000 is the range. It has to be within a $50,000 range. Now, this doesn't apply if the upper limit of the expected range is more than $200,000 in wages annually. Okay, so you won't have to worry about it for those positions making money in that range. Another requirement is actually a no requirement, no Canadian experience requirement. So an employer is going to be prohibited from including any requirement related to Canadian experience in a job posting or associated job application form. There's also going to be a requirement to disclose the use of AI. So an employer will be required in the job posting to indicate if it is using AI to screen, assess, or select applicants. There also needs to be a statement regarding job vacancy. So an employer will be required to include a statement in the job posting about whether it's for an existing vacancy and any other information as may be prescribed. We don't have anything else as of yet. So right now, just is it for a vacant position or not? There's also going to be a new requirement with respect to advising candidates of hiring decisions. So any employer who interviews an applicant for a publicly advertised job posting has this obligation within 45 days of the applicant's interview or last interview, if there's going to be multiple interviews, to advise the applicant of whether a hiring decision has been made in respect of the position. This is basically the rule against ghosting. It can be provided in person, in writing, or by using technology. So lots of options for employers to convey this information, but again, has to be done within 45 days of the interview. And finally, there's going to be a requirement to retain job postings. So an employer is going to have to retain copies of every publicly advertised job posting and associated application form for 3 years after public access to the posting is removed. And they also have to retain a record of the information provided to applicants who have been interviewed for that 3-year period as well. Now, January 1st is very fast approaching, so make sure you review your policies, particularly in regards to hiring, and ensure staff involved in the hiring process are aware of the requirements and properly trained on them. We've helped several clients get ready for these new requirements, so if you have any questions or you need assistance, please don't hesitate to reach out to us. Other new requirements, just really fast. The Working for Workers 7 Act, Bill 30, is out there, but it's not been passed yet. So it's currently in third reading as of October 29th. If passed, this is going to introduce several changes to the Employment Standards Act, the Occupational Health and Safety Act, and the Workplace Safety and Insurance Act. Just really quickly, in terms of the Employment Standards Act changes, there's going to be a new requirement, kind of in line with the job posting requirements of anyone operating a job posting platform is going to have a process for a user to report a fraudulent publicly advertised job postings. So there continues to be this concern about job posting management. So Indeed, Monster, Glassdoor, anybody operating one of these public platforms is going to have this process. There's also apparently going to be an introduction of a new job seeking leave, which is only going to apply if 50 or more employees receive notice of termination in the same 4-week period. So, in a mass termination scenario, an employee who receives this notice is going to be eligible for 3 days of unpaid job protected leave to look for new employment. There's also potentially going to be an introduction of a new extended layoff of more than 35 weeks in any period of 52 weeks, but not more than 52 weeks in any period of 78 consecutive weeks. And this is going to be applicable only where the employer and the employee agree, and the director of employment standards approves the longer period of layoff. So a new kind of third option for temporary layoffs potentially being introduced, as opposed to kind of the 2 durations that we currently have. I'm going to stop there because I know we're kind of trying to go through this quickly.
Awesome. Well, thank you. I know you kept going, but yeah, it gets really complicated. Just trying to follow all the numbers you threw out there had my head spinning. So yeah, it is. We're going to keep saying it. It's critical to work with your employment lawyer to get the advice. And temporary layoffs is probably the best example. And we went through this in COVID, which I can't believe it was 5.5 years ago. But all of the employers who assumed they had the right to put their employees on temporary layoff, and we've seen how the cases have evolved, and they usually did not have that right. And I will pat us collectively on the back, because when we worked with our clients, we were really insisting that clients have temporary layoff clauses in their contracts long before COVID. And although many of them, did not like the idea, they all appreciated that flexibility when who foresaw a pandemic. But when that occurred, they had a lot more flexibility without the risk that other employers had. So anyways, it just keeps getting more complicated, which is even more reason why you need to have a good working relationship with an employment lawyer. All right, so next topic, it is, I think, legally required in 2025 that if you do any kind of webinar, you have to talk about AI at least to some degree. So David is back and he's going to talk about AI in the workplace in 2026.
Thank you, Stuart. So like you said, AI is here. We can't ignore it. So the next best thing you can do is to learn how to use it optimally. And in the workplace, this is particularly important because there's not a lot of regulation or legislation with respect to how employers have to use AI. So this can create situations where employers just think they can kind of do whatever they want. But as we have found out recently, this has led to a few interesting cases where it has turned out that employers can actually be held liable for the actions and decisions their AI takes. So I'm just briefly going to discuss some more of the common uses of AI in the workplace, what the key risks and concerns are, and then talk about what employers can do to address these risks and use AI optimally. So we commonly see AI in the workplace in the following areas. Employers are starting to use AI for employee or customer support, such as by using chatbots to provide information or answer questions. We see AI is becoming very popular in recruitment and hiring. So employers are using AI to review and screen applications and make decisions throughout the recruitment process. And we're also seeing AI used in employee performance management, where AI assesses performance and determines if targets are being met. So the benefits of these uses of AI are clear, and they do make processes more efficient. The issue is that employers tend to focus and get tunnel vision on the benefits while ignoring the risks and employees' concerns. So it's really important for employers to understand that, as I mentioned, they can be held liable for the actions of their AI. And it's also important for employers to understand the concerns of their employees. So let me outline some common risks and concerns. The first thing I want to mention is that AI can inadvertently breach privacy or confidentiality. So this is something that, for example, can happen when you're using a tool such as ChatGPT and inputting confidential or personal information. So some of these AI tools will share all input with the developer or other third parties. So it's really important to be mindful of that when using AI. Another risk is that AI can give incorrect or wrong information. And there was actually a case where Air Canada's chatbot gave a customer the wrong fare information, which the customer relied on, and Air Canada was held liable for the damages in that case. So this isn't a theoretical concern. Likewise, we have discrimination. So as I mentioned, AI is becoming more and more popular in hiring. The issue here is that AI can actually make hiring decisions that are discriminatory, such as preferring male candidates over female candidates. And this is actually something that happened to Amazon, where its AI hiring tool was actually preferring male candidates, and they had to scrap the tool because it was just making all of these discriminatory decisions. And the last point I want to touch before I move on to how to future-proof your workplace is employees do have a lot of concerns about AI, and this is creating a lot of anxiety in the workplace. And this is leading to potentially lower morale and higher turnover, because employers can fall into the trap of thinking of AI as a way to cut labor rather than of thinking of AI as a way to boost productivity and enhancing worker output by cutting out menial tasks. So it's common to hear employees express their concerns in that regard. So given these risks and concerns, we have the following recommendations to quote unquote future-proof your workplace.
I'm assuming this can all be covered in about 30 seconds, right?
This will be covered in 30 seconds.
Yeah, you can't need more than that for future-proofing AI. So.
Absolutely. So the first thing I want to mention is employers need to implement policies on AI to establish clear rules and expectations for employees to follow when using AI tools, such as requiring employees to anonymize confidential information or use a closed system that doesn't share data. Likewise, employers should provide employees with training on AI in a way that enhances their productivity and provides them with useful opportunities to use AI in a work that lets them do more meaningful work while offloading the menial tasks to AI. And this is something that also helps transition in the workplace. And then finally, because AI can make mistakes and give wrong information, it's really important for employers to establish a human oversight role, such as an individual or department that essentially double checks AI's decisions and output before following through, just to make sure that, for example, there's no wrong information being given out, or that it's not, there's no discrimination going on. And I'll just wrap up with saying that the bottom line is that the AI is only as good as its users. So policy and training are key.
So thanks, David. And I'm pretty confident that as a firm, we'll be putting out more information on AI in the workplace in the coming months. And also, if you go back to previous episodes of Fire Away, you'll see some pretty interesting discussions that we've already had on this topic. So thanks for covering that. And we're going to now shift to talking about litigation. So we're going to have Jeff and Alex, I believe, are going to tag team on this. To talk about what we can expect to see in the world of litigation in 2026. So I think, Jeff, you're going first, right?
Yes. Yeah. Thank you, Stuart. Yeah. So as some people may know, effective October 1st, 2025, the limit on claims in the Small Claims Court of Ontario increased from $35,000 to $50,000. We think this is potentially going to have a fairly dramatic impact on the employment law landscape and litigation landscape. Because there are certain cases where we're at that threshold between 35 and 50 where it doesn't make sense to go in small claims because it wouldn't be enough of a potential recoup. But it's also going to cost too much to go to Superior Court, and it may take too long, and it's just going to get stuck in the morass of the Superior Court system, which I'm going to talk about in a second. So this increase of $50,000 may be beneficial for employment law cases. From my perspective, what I see as being really great about this increase is the potential access to increased amounts of mediation, increased mediation access for all employees. And I know Stuart is very pro mediation, so again, I'm relying on this, and so I expect Stuart to jump in at some point with this. As we may know, In Ontario, there is not mandatory mediation across the province. I think there should be, but there isn't. It's available or it's mandatory in Windsor, Ottawa, and Toronto. Everywhere else, mediation could take place in the Superior Court system, but it's not a mandatory component of the process. In the small claim system, there is ostensibly mandatory mediation in the form of a settlement conference, which is going to take place a period of time after the parties have exchanged pleadings and pleadings have closed. The settlement conference is like a mediation almost on, not on steroids, but I guess on creatine. Because it's a little bit more of a deciding factor because you're going in front of a deputy judge. This is not going to be the same deputy judge who's going to have carriage of the matter if it goes to trial, but the deputy judge is going to have read everything, reached an assessment. It's hopefully going to be a deputy judge who practices in the area of employment law, and is going to be able to provide their take on this and try to get the parties to settle. And the benefit of this is it's automatically scheduled. The parties don't have to agree to it, and it's going to go forward irrespective. And it may resolve a lot of things. The other thing I think this is going to have an impact on the rules of civil procedure have a provision that if a matter is brought in Superior Court, either by a simplified procedure, which is from $50,000 to $200,000, or in the regular rules, which is over $200,000, and the court finds that it should have been brought in the small claims court, this can have a negative impact on the plaintiff's assessment of costs. Even if the plaintiff is successful, they may not be awarded costs or may not be awarded costs as high an amount. So we might see this because of the higher amount, the higher upper limit of the $50,000. The one drawback, or I don't want to say drawback, a shortcoming in terms of these small claims court is that they cannot provide equitable relief. Because they are a statutory court, they can only provide monetary relief. They can still give reasonable notice, they can still give punitive damages and so forth, but they can't give an injunction, they can't give a simplified, an order for specific performance because they are not an equitable court because they don't have inherent jurisdiction, they're a statutory court. So it'll be interesting to see how that shakes out in the long term. And in terms of just the litigation system and situation in general, I can speak to Ontario specifically, but I understand this is a cross-country problem. We are still seeing very much the residual impacts of COVID at almost every aspect of tribunal or court system. So if you want a motion, it's going to take you a while to get one. Alex can speak to this a little bit more because Alex has more firsthand experience in this recently. The Human Rights Tribunal as well is very backed up. You're seeing years before you get to hearings. In my experience, they are starting to really put the foot on the gas in terms of mediations. I had a file recently where the file was brought in March and we had a mediation in November, which is lightning fast for the Human Rights Tribunal. And the Ontario Labor Relations Board continues to be the place if you want speedy justice to go to. If your case fits in there, you want to go there because they're a very well-oiled machine at the Ontario Labor Relations Board, strictly because of their requirement to deal with the union stuff, and union stuff has to get turned around fast, so everybody kind of benefits from a side effect of it. But the Superior Court system and the Court of Appeals system continues to be, there's a lot of cases in it, and it's very backed up, and they need more resources, I think.
Yeah, that sounds like a pretty good update. And I'll just throw in one thing. Where Human Rights Tribunal, as you said, is hopelessly backlogged, and we're seeing delays of up to 5 years before anything happened on a case. But interestingly, in recent times, they seem to have been, doing everything they can to clear the backlog by dismissing as many cases as they can. Yeah. So, and this is directed more to individuals. If you are contemplating or if you filed a complaint, I should say, with Human Rights Tribunal, they're dismissing them for administrative reasons, and often it doesn't seem like it's justifiable, especially when notice isn't properly given. So if you have a file or a complaint that you're waiting to hear about, you might want to reach out to the tribunal to see what's happening with your complaint. All right, and Alex, I'll kick it over to you to finish the update.
Thanks, Stuart. So I'll talk about changes to the court's rules. So this is very specific to Ontario, but there are potentially some very significant changes coming to the litigation process in Ontario, which will impact how employment law cases proceed. So in January 2024, Ontario launched a civil rules review working group, which is making recommendations for overhauling the civil litigation system. The goal is a faster, cheaper, and more accessible system, and it's designed to address the type of delays that Jeff spoke about, type of delays that many litigants have experienced. What they're proposing is a full redesign of the system, not just minor tweaks. So some of the key changes that the working group is proposing include the elimination of examinations for discovery. They're proposing an upfront evidence model, which would include the early exchange of sworn witness statements, which would form the party's evidence in chief at trial. They're proposing simplified pleadings and service rules, narrower documentary disclosure, active case management. So the court would be involved in managing how cases move forward, a new summary hearing process, and mandatory mediation of all cases. So, another point raised by Jeff that mandatory mediation is currently in only certain jurisdictions. They're proposing to make this universal. So altogether, this would be very significant changes. The stated goal is to have a full hearing, such as a trial, scheduled within 2 years of a lawsuit commencing in most cases. So this potentially has a significant impact on employment law cases. If all goes as planned, this could lead to lower costs, faster timelines, and trials becoming more realistic options so that parties aren't required to reach a settlement just to avoid the cost and delay associated with the litigation process. Going through the process could actually be a realistic option. So this review is an ongoing process. I am very much in favor of these changes, but not everybody is. So it remains controversial, including eliminating examinations for discovery. That's a very controversial proposal. So we'll see what changes are ultimately made. The goal is to have these changes implemented at some point next year. So this will be something to watch, and it's certainly a process that we are going to continue to monitor.
Thanks, Alex. And yeah, I mean, speaking, I'll sound like the old guy here. Speaking as someone who's been practicing for 26 years, like these are monumental changes. It's not just a tweak to the system. And it's still, like you said, still being discussed and negotiated, but it'll be very interesting to see how much of these changes actually get through and are approved. So we will update everyone as things go through the process in 2026. Our last topic looking forward to 2026 is Nadia returning to talk about return to the office mandates some more and just sort of pick up on the comments you made earlier. So Nadia, I'll turn it over to you.
Thanks, Stuart. There's a lot of returning, pun intended. So the trend toward full-time in-office work is accelerating in the public sector and beyond in 2026. In August, the Ontario government mandated that all 60,000 Ontario public service employees must return to the office full-time starting in January. So that's what we're expecting in a couple months. Brampton Mayor Patrick Brown has also directed municipal staff to return to the office full-time beginning in January. And across Toronto, private sector employers are following suit. And this is essentially tightening the hybrid work schedules that became common during the pandemic, which is, of course, pushing more workers back into daily commutes. We can expect that return to office mandates will continue to grow in 2026. So what does this mean for employers and employees? If you're an employer, you should seek legal advice from an employment lawyer to ensure you comply with the law, maximize your rights and flexibility, and minimize your potential liability before implementing return to office mandates. We regularly help our employer clients in such situations. This includes, but is not limited to, ensuring you have proper contracts and policies in place so you can effectively manage the workplace instead of being on the hook for potentially substantial liability. And if you're an employee, you should also seek legal advice from an employment lawyer before agreeing to or accepting the changes proposed by your employer. Otherwise, you may be sacrificing your rights or leaving money on the table. And again, we regularly help our employee clients get what they're entitled to.
All right. Thanks, Nadia, for the follow-up on that. And yeah, we will probably also have a lot more to say over the course of the year as this return to work unfolds. So that brings to an end the second section of this episode, which is the look ahead. Last is a brief Q&A session. We've received a couple of questions from people that I wanted to get to. So Brittany, I think we've combined the first two, which were pretty similar. So I'll give you the questions and then leave it to you. So the first question was, a disabled person on long-term disability benefits reaches age 65 and their insurance terminates in accordance with the group insurance contract. Are they entitled to severance? Is there a frustration of contract? Should an employer have a policy to address this event? That's question one, a very related question. When a carrier terminates long-term disability benefits at the change of definition, which, just to make sure everyone understands, typically happens after 2 years of disability, where the definition of disability changes from own occupation to any occupation. So at that point, the employee still cannot return to work. They bring a claim against the insurance company and assume that they get some sort of settlement. But how should the employer address issues of accommodation or termination or frustration at that point? So a lot to decompress there, but I'll leave it over to you, Brittany, to unpack that.
Okay, great. Thanks, Stuart. So I think what's important to understand is that there is a distinction between the concepts of entitlement for long-term disability or LTD benefits, the duty to accommodate under the code, and the concept of frustration of contract. So regardless of whether an employee is denied or approved for LTD benefits, an employer continues to have a duty to accommodate under the Human Rights Code up to the point of undue hardship, which we've talked about quite a bit in this presentation so far. So, as an example, an employer may still have an obligation to accommodate an employee by allowing them to remain on an unpaid leave of absence if their medical documentation supports their inability to continue working, even if their LTD claim is denied or the benefits cease. In this case, the employer would want to request medical documentation from the employee to understand what are their current restrictions and limitations, what are the expectations with respect to recovery. We always recommend having employees get their doctors to complete a detailed functional abilities form that asks specific questions about restrictions and limitations, about prognosis in terms of recovery time or next assessment if recovery time isn't knowable at that point in time. This is really going to give you the sufficient information to allow you to assess options for accommodation rather than just relying on generic doctor's notes, which often don't give you enough information to really understand what the restrictions and limitations are, and how you could potentially accommodate the individual. Now, I want to talk a little bit about frustration of contract. This occurs where the contract becomes impossible to perform due to an intervening event that is not the fault of either party. So, when we are talking about an employee who is unable to work, the question is there any reasonable likelihood that this employee will be able to return to work in the foreseeable future, right? If there's no chance that the employee is going to be able to return to work in the foreseeable future, that's when you hit the point of frustration of contract, where the contract cannot be performed and it's not the fault of either party, and everybody's obligations kind of fall away, with the caveat I'll mention in a little bit. Again, the answer to this question is not determined by whether someone is denied or approved for LTD benefits. It depends on the medical documentation. So you're going to want to have documentation if you're going to allege frustration of contract that shows that this threshold of the employee having no reasonable likelihood of returning to work has been met. And one of the things that we often recommend doing in our functional abilities forms when we prepare these is we always add that question. We just straight up ask, is there any reasonable likelihood of the employee being able to return to work in the foreseeable future? And if the doctor indicates no, that's going to be very clear, helpful evidence for you when you're arguing that you've reached the point of frustration. Now, policies, I'm going to talk about this a little bit because I thought this was a great question about should you have a policy in the event of this life event. It's a great idea to have a policy regarding accommodation, including the ability of employer to request supporting documentation and the employee's obligation to cooperate with the process. I think both Nadia and Stuart talked a lot about how this is a cooperative process. It's a conversation. It's not just falling on the shoulders of the employer, including requiring or having this expectation set for the employee that they're going to have to provide supporting documentation when that's requested. But what you need to be careful of in any policy is trying to predetermine when you've reached the point of undue hardship or frustration. You have to remember that frustration is based on medical evidence, not time, right? So there's no period of time after which you can say, well, it's been 2 years. That's a wrap. We've now hit the point of frustration. That's not the way it works. So no time period and no event, such as LTD benefits being approved or denied, is going to mean that frustration is automatically established. The final thing I'll say is that caveat I mentioned earlier is that you want to keep in mind that when the employment relationship is frustrated due to illness, employees in Ontario will still have some entitlements on termination pursuant to the Employment Standards Act. So you also don't want to have a policy that says you don't get anything in the event that there's a frustration of the relationship. So hopefully that addresses the two questions. I tried to keep it a little bit more general. But yeah, really important to just kind of take away is frustration is not something that happens automatically due to time or due to an event taking place like LTD being approved or denied.
Thank you. And you took my summary was going to be exactly what you just said. So because we get that question all the time. How long do I have to wait before I can deem them to be frustrated? And it doesn't matter. It can happen instantaneously if the person is in a horrific car crash and it's clearly never going to work again. Or, we've seen cases where people have been off on medical leave for 10 years. So yeah. All right, we'll take time for one more question, and this is actually a bit of a consolidation of questions that we are often asked, but it seemed to be particularly timely as I look at all of our festive holiday backgrounds, including my own, which I feel like I'm a news reporter. Sort of, I feel like I should be coming in and saying I'm reporting live outside the offices of Rudner Law as a shinny game is broken out nearby. But anyways, in light of the upcoming holidays, we often get questions or requests for tips about how to handle holiday parties. So, Nadia, if you can give people at least a few tips in that regard, that'd be great.
Thank you, Stuart. So office holiday parties are common during this time of year, and they typically offer a relaxed setting to boost staff relationships and workplace morale. But these events can also pose legal and practical risks for employers because, let's face it, employees sometimes forget that these are work functions. So, to mitigate issues like harassment or other liability, employers should have and enforce clear policies, including those for sexual harassment and responsible drinking, making it explicit that they apply offsite. We regularly assist our employer clients to prepare and implement such workplace policies. Now, everyone in the workplace should be aware of the policies, and managers in particular should be trained, understand they represent the organization, and ensure compliance with such policies. At holiday parties, employers would be wise to control the flow of alcohol and take measures to prevent drinking and driving and ensure safe travel home. And finally, you should recognize all backgrounds and religions that are represented in your workplace. Now, when it comes to employees, the tips are more straightforward. Basically, make the most of any holiday event by getting to know your colleagues and superiors, but don't do anything that will damage your or your employer's reputation.
Well, thanks, Nadia. And yeah, on that last point, I mean, you got to remember it's still a workplace event. And I guess the one thing that everyone needs to remember is workplace policies still apply, even if you're outside the four walls of the workplace and you're off at a party somewhere else. So thanks. Hopefully, I think a lot of organizations are going back to having holiday parties again. So hopefully people will enjoy them. That brings us to an end of the Rudner Law year in review, not the end of the story, because employment laws, both legislation and court cases, will continue to evolve and to change. We often refer to employment law as being like a pendulum. It swings back and forth between trying to balance the legitimate business interests of employers and also protecting individual rights. So currently, especially when it comes to things like termination clauses, the pendulum is farther on the employee side than, frankly, I've ever seen it. We'll see where it goes in the future. One of the things that never changes, though, and we always say this, but I will say it again, the reason that firms like ours are always so busy is because people don't treat their employment relationships as legal relationships. They make decisions without considering the legal implications or getting legal advice. And the ones that end up spending the most money, and I'm talking on the employer side here, are the ones that are purely reactive instead of proactive. They're the ones who call us after they get the demand letter, as opposed to calling us before they contemplate the dismissal so they can get proper advice. And just on that point, I will say that one thing that has changed, at least in our firm, is how we try to bill for our services. So traditionally, of course, legal services are billed based upon time. And, that's always the 0.1 and 0.2 increments. And often when we have clients call us and say, we just got a demand letter for this individual who claims they were wrongfully dismissed, and we will ask them, how come you didn't call us before you dismiss them? The answer we get is, well, we didn't want to pay the cost of getting legal advice. So one thing that we're doing, and I think we're in the minority of law firms, is trying to get away from the billable hour. So we're offering project fees, fixed fees, and also subscription arrangements, which I kind of think of like Netflix. You pay a fixed monthly fee and you get essentially unlimited advice. So you don't have to worry about paying for every email, every phone call. And ideally, our clients will call us before they do things so that we can help them to avoid a problem rather than trying to fix it later, which is almost always more expensive. So last thing I'll say in terms of being strategic and proactive, people are watching this already know you need to stay up to date. So follow online sources. We offer great blogs, great social media, fire away. Other firms do as well, but make sure you stay up to date. Have an ongoing relationship with an employment lawyer. Obviously, we'd love it to be our firm, and we'd be happy to talk to you about that. But as long as it's it's a lawyer that focuses on employment law, not a general lawyer, then you should be well covered. But have the ongoing relationship so that you don't need to explain to them who you are and what you're about when the issue is urgent. And last but not least, I will just repeat the offer I made earlier that we'll be happy to take a look at your employment contract templates. And I will challenge you to send them to us because I am betting that at least 3/4 of them will include termination clauses that are not enforceable. So please feel free to send them. There's no cost and no obligation. And with that, I'll turn over to Brittany to wrap things up.
Thanks, Stuart. So that's a wrap for this special episode of Fire Away. It's episode 95, if you're keeping track. I want to thank the Rudner Law team for their contributions to the podcast. Great job, everybody. And also our amazing production team for helping put the show together. Thank you very much. And of course, thank you all for watching or listening. Please subscribe and like our podcast and YouTube channel to receive regular updates on upcoming shows. You can check out the rest of Rudner Law's social media to keep up to date on HR law issues. And to quote one of Stuart's favorite hockey broadcasters, the pleasure was all ours.
I didn't know if you were going to include that, but thank you. So
I changed it to your name. I don't have a favorite hockey broadcaster.
That's shocking. All right. Well, thank you to everyone for watching or listening. And please keep in touch with us. And if you like this one, then like and subscribe to us and follow us on YouTube so that you can get all the episodes as they come out. And with that, I think on behalf of everyone at Rudner Law, we want to wish all of our friends, our colleagues, and everyone watching a very happy and healthy holiday season.
At Rudner Law, we want people to treat their employment relationships as legal relationships and make informed decisions rather than assumptions. Keep up to date on Canadian employment law issues by following us on Twitter, Instagram, LinkedIn, and TikTok, liking our Facebook page, subscribing to our YouTube channel, and signing up for our newsletter. Past episodes can be found on YouTube, on our website, and archived on Facebook. And if you like our page or subscribe to our channel, you will receive notifications when the episodes are live. As we always say, none of that replaces legal advice tailored to your specific circumstances. If you think you might need an employment lawyer, you probably do. So please don't hesitate to reach out to us.